This is Brian Dean Abramson, author of the legal treatise Vaccine, Vaccination, and Immunization Law, presenting Vaccine Law Part 2 for Quimbee. This course covers the last two major areas of vaccine law, vaccination mandates and vaccine injury compensation. A vaccination mandate may generally be defined as a requirement that individuals receive one or more specified vaccines or experience some consequence of not receiving them. Most commonly, this consequence will be the denial of access to locations, such as schools or hospitals, or activities, such as employment or education more broadly. Vaccination mandates are nearly as old as vaccines themselves, but the authority for their application is much older. Prior to the existence of vaccines, governments used quarantines and isolation to counter infectious diseases. These practices also remain in use today, with the United States Centers for Disease Control stating that isolation and quarantine help protect the public by preventing exposure to people who have or may have a contagious disease. Technically, isolation is specifically the separation of people who have an infection with a contagious disease from people who are not infected, while quarantine separates and restricts the movement of people who are exposed to a contagious disease but not known to have that disease yet, to see whether they have in fact been infected. As far back as the 1902 case of Compagnie Française de Navigation à Vapeur versus Board of Health of the State of Louisiana, the United States Supreme Court upheld laws requiring involuntary quarantine of a vessel during a yellow fever outbreak, finding that this was a reasonable exercise of state police power. Most early vaccination mandate cases involve smallpox vaccination. The smallpox vaccine was invented in 1796 and became widespread around the world within a few years. Many countries mandated vaccination of smallpox before the United States did, and in the United States, many states and municipalities adopted vaccination mandates to prevent epidemics of the disease, primarily in the latter half of the 1800s. In the late 1800s, various state court cases arose challenging these mandates, often on procedural grounds regarding their implementation by state agencies, with questions arising as to whether those agencies had properly been delegated the authority to mandate vaccines. The first vaccination mandate case to reach the United States Supreme Court was Jacobson v. Massachusetts in 1905. The state of Massachusetts had enacted laws enabling municipalities within that state to mandate vaccination of all people living in that municipality and to impose a penalty, a $5 fine, on any person who refused to be vaccinated. A suit against the law was brought by Henning Jacobson, a pastor of Norwegian origin who had lived through previous smallpox epidemics in his home country and who argued that the vaccination requirement violated his bodily autonomy. The state courts upheld the law. The Supreme Court, reviewing the matter, found, in this matter of first impression, that it is within the police powers of the state to mandate smallpox vaccination to protect the public health generally. The court noted that Jacobson might have a valid objection if he could provide evidence that vaccination would endanger his life. But in this case, he had only articulated speculative concerns to the effect that there was a danger to him based on poor reactions to the vaccine by family members and by the general knowledge that some recipients of the smallpox vaccine had bad reactions. This was a 7-2 opinion, with the two dissenting justices not writing a dissent. The only other case in which the Supreme Court directly examined vaccination in the 20th century was Zucht v. King in 1922. In that case, the San Antonio School District enacted an ordinance requiring all students attending public or private schools in the district be vaccinated for smallpox as a prerequisite to attending school. The Supreme Court applied the reasoning of Jacobson to the case and unanimously and quickly found that if the state can mandate vaccination, it can certainly engage in the less intrusive conduct of conditioning access to the schools on vaccination, and therefore can prohibit unvaccinated students from attending school.